Hello everyone! In this video, we are going to share to you some of the important concepts of conflict of laws. I am Bay Mariana A. Salman.
Hi, I'm Alamin Silo.
Hello, I'm Bayhas Myra M. Ginzon.
And I'm Baby Nanan Tupina.
Hi, I'm Ana Duhali.
Hello, and I'm April.
The most important component of a conflict of law problem is the presence of foreign element. It is anything which is not domestic and has foreign component to it. Without this element, the case is only a domestic problem and has no conflict dimension. As further explained in the case of Saudi Arabian Airlines versus Court of Appeals, foreign element is inevitable since social and economic affairs of individuals or association is rarely confined to the geographic limit of their birth or conception. Without foreign element, the case is only a domestic problem.
Hi there. Let's discuss the phases in resolution of conflicts of law. There are three phases: jurisdiction, choice of law, and recognition and enforcement of foreign judgments. These phases are separate from each other and are important in determining the applicable theories of law as well as the defenses available thereto. In Kitamura versus Hasegawa, jurisdiction is defined as the power and authority of the courts to hear, try, and decide cases. Now the second phase is choice of law. In this phase, two questions is sought to be answered, as provided for in the case of Continental Micronesia versus Baso. First question, what legal system should govern or control a particular situation wherein some of the given facts occurred in two different states? And the second question is up to what extent this legal system should regulate the given situation. Now the third phase, and the last one, is the enforcement and recognition of foreign judgments. In this phase, those who seek for the enforcement and recognition of these foreign judgments should follow particular procedures in order for the court to recognize such foreign judgments. Without following these procedures, the court may presume that the laws or the judgments or the legal principles in the Philippines is the same with what is being applied in the other countries involved in the case. Now, those are the three phases in resolving conflicts of law. Remember, each of the phases are distinct from each other, and that the defense from one of the phases cannot be used or is not a defense for the other phases.
The forum of non-convenience simply means that the forum is not convenient. It may be that the chosen forum or venue where the suit is filed has no substantial connection to the parties, that it may become very inconvenient for them to litigate the suit in the chosen venue. It may happen that the parties to the case are not residents of the forum, or that the witnesses are located somewhere else in a jurisdiction which provides a more convenient forum to litigate the case. The jurisdiction could also be an adequate forum where courts of law are operating and may offer the plaintiffs a venue where they could obtain justice.
One of the most important concepts in the conflict of laws is the characterization. It is a process of deciding whether or not the facts relate to kind of question specified in the conflict rule. It is also called as classification. It is the process of assigning a disputed question to its correct legal category. The process of characterization is also called as doctrine of qualification. It is a step in conflict rules cases which assign the particular case into a classification based on the subject matter of controversy.
Service of summons can be done in three ways. First, by personally handing the copy of the summons to the defendant in person. Second is by substituted service or by leaving copies of summons at the defendant's residence with person of suitable age and discretions residing therein. Lastly, by publication in a newspaper of general circulation for service upon defendant whose identity and whereabouts are unknown.
The principle of effectiveness is one of the reasons why we say that the forum is inconvenient. The judge has no right to render judgment, and if cannot, then there is no point in acquiring jurisdiction and pronouncing the judgments, since the court cannot render judgment at all. In the case of Islamic Republic of Iran versus Pahlavi, where the former Shah of Iran and his wife were accused of embezzlement, the U.S. court dismissed the petition on the ground that the litigation has no relation to the state of New York other than the presence of the former Shah and his wife, and that the properties sought for constructive trust were located in Europe. In comparison to Republic versus Marcos, the U.S. court granted the petition to prohibit the sale of properties in New York. Forum non-convenience is inapplicable in this case because the properties were in New York and not outside.
Theories and application of foreign law. There are 5 theories. First is the theory of comity, which rests upon the principles reciprocity and persuasiveness of foreign law. Second, the vested rights theory. It enforces the rights vested from laws and judgments emanated from the foreign state. Third, the theory of local law. It enforces the foreign law because our local law requires us to do so. Fourth, the theory of harmony of law. Identical and similar problems should be addressed with identical and similar solutions. And lastly, the theory of justice. The proper law should be applied in order to obtain justice.